9 o'clock on this Tuesday morning. I am Rekha Muttaraj here with Sherman Chow, and we come on with breaking news as embattled Attorney General Ken Paxton is now in a Harris County State District Court for a pre-trial hearing for his securities fraud charges.
Yeah, the state's highest law enforcement official charged with recruiting investors for a Dallas-based tech company without revealing that he was being paid by that company, and for steering clients to a friend's investment business without registering with the state securities board. But the Austin American-Statesman's reporter Tony Poletsky reporting that Paxton and state prosecutors could reach a deal, making this 9-year-long case come to an end.
And we are going to stream this live. The judge is allowing audio, but not a camera in the courtroom. So the picture you will be seeing is just outside the courtroom, looking in, but listening in. Let's go ahead and go to it.
Can we approach?
Yes.
May we approach, Your Honor?
Yes, but just so you're aware, I believe I'm on a live mic right now. So.
I'm sorry.
Do you know this or not? It's an agreement between us, so I don't think you need to sign it.
I'm fine with not.
That's fine. That's what I think.
That's fine, Your Honor.
Yeah, perfect. Thank you.
Thank you, Judge.
We are ready on this whenever.
Okay, and I believe he just needs to be sworn to it, and then we can go on the record.
Yes, ma'am.
Dan, you want to keep this document together?
Are y'all ready to swear him?
Yes, ma'am. You were
Talking
asking
to the
Dan?
clerks, yes. It's a PTI contract.
Yeah. My understanding is this is not filed. State certificate is not filed.
That is my understanding as well.
You can leave that, but it's not going to contain his that's still your report.
And do you agree to abide by these in every stipulation?
Yes.
And they won't be, you know.
Okay.
Are you ready, Carrie? Are the parties ready to go on the record?
Yes, ma'am.
Yes, Your Honor.
Yes, Your Honor.
Okay. This is cause number 1555100 and 1555101, State of Texas versus Warren Kenneth Paxton Jr. And it's my understanding that the state and the defense have come to an agreement in this case.
We have, Your Honor.
We have, Your Honor.
That's correct, Your Honor.
And that's to enter a pretrial intervention contract.
Yes,
It is, Your Honor.
Okay. And this case was filed quite some time ago, and by my count, I'm the fourth judge on this case. And when I inherited the case, I ensured that justice would no longer be delayed and set the case for trial on April 15th. In state, you understand that I have refused defense's attempts to get the case dismissed to this point. by their own motion and was ready and prepared to go to trial on April 15th.
The state understands that, Your Honor.
And no judge can force a prosecutor to present evidence or call witnesses. And so understanding that, you are waiving your right to a jury trial. The prosecutors in this case will not be going to trial on this case and are instead entering this pretrial diversion contract.
That is correct, Your Honor. It is.
And defense, you are waiving any further speedy trial rights from this date forward, correct?
We are, yes, ma'am.
So if the contract is violated, you understand, both sides understand, that this court will be setting a very speedy trial.
The state understands that, Your Honor.
Defense?
Yes, ma'am.
Okay. And defense, you understand that this contract is not an agreement from this court. This court does not have any say in this contract, and instead the contract is purely an agreement between you and the prosecutors on this case.
We completely understand, Your Honor. Yes, ma'am.
And state what are the terms of the agreement generally?
Your Honor, the terms of the agreement generally are that the defendant will be on an 18-month pretrial intervention agreement with the state of Texas. He will be required, among other things, to make full and complete restitution to the victims in this case, Byron Cook and the estate of the late Joel Hochberg. This defendant will be required to complete 100 hours of community service in Collin County, an entity or organization that Mr. Cogdell and I will agree upon, that this defendant will have to enroll in and take 15 hours of legal ethics as part of a continuing legal education course sponsored by the State Bar of Texas. In addition to that, which he performs as an attorney, and that he will agree to be supervised by Mr. Silverman and I by reporting, at least at this point, once every 60 days virtually.
And what is the total amount of restitution?
Your Honor, I can give the court the exact amounts, but I think we can agree that it's somewhere a little bit south of $300,000.
Okay. And Mr. Paxton, this is your signature on the state's contract?
Yes. Yes, it is.
Okay. Does either side have anything further that they'd like to put on the record?
Just to thank this court for its patience. Other than that, no, ma'am.
And again, to echo Mr. Cogdell's sentiments, what this court has done in 7 months far exceeds what has happened in the last 9 years, and the court and your staff are to be commended, Your Honor.
Well, thank you both. And we'll be in recess on this case.
Yes, ma'am.
May we excuse, Your Honor?
Yes, sir.
Judge, we would like to confer with Mr. Wice and Mr. Silverman and Mr. Paxton. Can we go through that door to confer, or do you want us out the front door? It should take about 5 minutes, I think, Judge.
That's correct, Judge.
That's fine. I just can't give you access to any of the
Yes,
staff.
That's fine,
Judge.
Judge.
Yeah.
Right.
So tell us, I need this mic on, and I don't know who it belongs to.
Texas Attorney General Ken Paxton back in a Houston courtroom today facing those felony securities fraud charges, and it looks like a deal was reached. A pre-trial intervention contract was agreed upon, so Paxton will not be going to trial in April. But our KHOU 11 legal analyst Carmen Rowe is here to talk us through it, walk us through the conditions of this agreement. Carmen, are you there?
Yes, good morning, Reka. Good morning, Sherman.
Good morning. Go ahead.
No. Well, okay. I guess the first big question for all of us non-lawyers is, what is a pre-trial intervention contract, and how did Paxton achieve this?
Good morning, everyone. This is, an issue that was on the table before, an opportunity for him, but it seemed like it wasn't going to happen. So it's very surprising to see it happen this quickly and this close to trial. But essentially, it's an informal written agreement between the defendant and the prosecutors in this case that after 18 months and perhaps even sooner results in a total dismissal of all 3 felony charges.
All right. I guess one would say this is a win for Ken Paxton, who was facing 3 felony charges on these securities fraud questions. Maybe we should remind folks this was because he was accused of soliciting investors for, I believe, 2 different companies without advising the investors that he was going to get some of the management fees from their business, as well as not registering with a securities commission to do this kind of business. So kind of a big deal. This has been a 9 years long trial case going back and forth. The judge said she was number 4 on this case. Can you kind of recap for folks, Carmen, why this has been such a long, strung out situation and how it ended up here in Houston?
Sure. I mean, I don't know that I could give any justice to the actual procedural posture here because it, as you said, has run almost a decades long. But we started off in Collin County where the indictments were handed down. There was a lot of battles on procedural issues between 2 sets of very talented trial lawyers. Ultimately, the venue was sent over to Houston. Meanwhile, we went up to the courts of appeals here in Houston. We went up to the Court of Criminal Appeals in Texas, the highest criminal court, back down to Houston, back up to the Court of Appeals. And we're here today on a pretrial setting where this case was supposed to go to trial in just a week and a half. And so to reach this kind of resolution just 7 months after it came back here to Harris County is again, very surprising, especially as you mentioned, we're talking about 3 felony charges, 2 of which are first-degree felonies that could result in 99 to life in prison. And to go from there to what amounts to a dismissal after some terms and conditions are met is wide of the mark of what most people thought this case was going to turn into.
So as you mentioned earlier, the terms were the 100 hours of community service, the 15 hours of legal education classes dealing with legal ethics, which some people kind of find ironic considering his position. And of course, he has to pay restitution. We heard in the courtroom that the restitution is just south of $300,000. Paxton also in a separate case owes a settlement in a whistleblower case. How are all of these payouts going to happen? And are they connected in any way?
Well, I mean, unfortunately, as an attorney who practices here in Houston, I think this case does not reflect well on criminal justice, either in Collin County or in Harris County, because what it appears to be is that Kenneth Paxton was able to buy his way out of this criminal allegation, one that he essentially admitted to the basis of many times in the media prior to charges and after charges. The fact that he was able to delay this proceeding for almost a decade. He attempted to defund almost successfully the prosecutors who were coming after him for these criminal allegations. You know, again, it does not speak well of the criminal justice system. I can't see how Kenneth Paxton doesn't think this is a victory. And it's one that's come on the heels of several victories for him here in Texas, both politically and now legally.
And I'm not a legal expert, and I'm hoping you can obviously clarify this, but is this an admission of guilt with this deal, or is that not in black and white?
You know, I'm so glad you asked that. A lot of pretrial intervention agreements require that a defendant admit responsibility or guilt. In this case, it's quite clear that Kenneth Paxton was not required to admit guilt. And so this isn't a plea of guilty. It's not an acceptance of responsibility. It's a negotiated resolution of 3 serious felony charges.
You know, your phrase was wide of the mark, this solution, if you will. Do you want to speculate, and you may have hinted at this previously, but do you want to speculate how this happened?
Well, that would be tough to do. I wish I knew more. I'm sure a lot of people do. Most people thought Kenneth Paxton was really facing prison time on this case. But I, again, would, look to the talent, the almost 40 years of experience each individual trial prosecutor and defense counsel had in this case. I think it was a hard fought victory for Kenneth Paxton that a lot of the surrounding narrative played into, not the least of which was the impeachment trial that was unsuccessful that we saw right here live on KHOU. I think all of that played into this resolution. And of course, importantly, the judge pushing everyone forward and saying, we're not giving you any more time on this case. We are going to trial or you're going to resolve it.
You mentioned the defunding of the prosecution, and that, of course, has been a big deal. I guess the original negotiation was $300 an hour, and Kent Schaefer, one of the two prosecutors, actually just withdrew from the case fairly recently because he hadn't been paid. How does that come about? How can you not pay lawyers for doing their work here, the special prosecutors?
You know, I've never seen anything like it. There was a law change as a result of this case. There has been this attempt to defund. There's been the Texas Court of Criminal Appeals getting involved in fees for prosecutors. And then, as you mentioned, we have Mr. Schaefer, who actually withdrew from this case, which may have impacted and likely impacted, given the timing, this resolution. And, you know, it's one of those things that does not speak well to justice that a criminal defendant facing 3 felony charges could have such a sweeping impact on a case, and of course on the law and the way we pay prosecutors in Texas, which he absolutely did based on this case.
Ken Paxton was supposed to go to trial on April 15th. He is avoiding that now with this agreement. But will he face further charges or possibly a trial if he doesn't complete the terms of this agreement?
I mean, you have to believe that the highest law enforcement officer, as well as a licensed attorney, can follow the terms and conditions that are set out here. But in the rare circumstance that he does not, he would be back before this judge. He would be facing a prosecution, and they would move forward as if this agreement never existed. And so that's exactly what the judge in this case cautioned about, that if we're back here for any reason, we're going to trial, and I'm going to set this for trial very quickly and not allow this to continue to linger and, of course, cost us money here in Houston on this case.
Yeah, she hit that word speedy trial with a little bit of extra emphasis, so you could kind of feel where she was going with that one. They talked about restitution just being south of $300,000. Is that the money that Paxton would have garnered in terms of fees from these various companies, the relationship of which he did not disclose to the potential investors that he was going to get money from their investments?
Sherman, I'm not actually positive who's going to get that restitution, but it's meant to be assessed for 2 reasons. One, to reimburse victims of crime who may have lost that amount of money, or in other terms, at times it's used punitively to suggest that's the amount of money that he would have made and therefore he should pay it back. And so, Mr. Wice suggested that that's going to the victims in this case. And so we can surmise from that perhaps that's the loss that they faced as a result of his criminal conduct.
So as we mentioned, he first was indicted back in 2015, so we're talking almost a decade at this. And I'm wondering, prosecutors have alleged this and made these accusations as well. Was it just to completely exhaust options? They kept moving the trial location, exhaust resources, and that's how they were able to come to this? Because when you look at this in general, if someone who wasn't so high profile and was facing these charges, there's probably a good chance this would either, get settled sooner or go to trial.
Exactly. And that's why this is such a surprising outcome. Look, cases people get pretrial diversions. Cases are resolved this way all the time. But they're the kind of cases that don't get indicted, or they're resolved very quickly with a pretrial intervention because you believe the value of the case is ultimately a dismissal. This case was so aggressively fought at every level of the proceedings, all the way up, as I said, to the highest court here, the criminal court here in Texas. And so it's surprising that we could do all this battling, spend all this money, have so many lawyers doing so much work to get to a result that equals a dismissal on 3 felony charges. And so perhaps after today, we will hear from the parties and we'll have a better sense of why this may have been the outcome here. But I don't think that anyone is less surprised than I am that we're here today with, again, what amounts to a dismissal for Kenneth Paxton after almost a decade of litigation.
So this potentially speaks to the benefits of having deep pockets or lots of resources or political clout.
Yeah.
So does this potentially set a precedent for cases in the future similar to this?
Well, Sherman, you're absolutely right. I think it does speak to the amount of money and the powerful lawyers that were involved in this case. And of course, the impact or power that Kenneth Paxton wields from his position as the Attorney General. And that's what I think does not reflect well on our system of justice today. That said, this is a case that has been rare, unusual, unprecedented from the beginning. It has been for almost 10 years. And I don't think that today's outcome is going to impact other cases in the future. And I hope that the political system that sometimes finds its way into our criminal justice system doesn't have this impact in the future, but only time will tell.
Carmen, stay on the line with us. For the folks who are just joining us on air, we're going to go ahead and listen to that hearing or part of the hearing. It went by pretty quickly. You're going to hear from key players in this case, including the Judge Andrea Beall. Let's listen in.
Byron Cook and the estate of the late Joe Hochberg. This defendant will be required to complete 100 hours of community service in Collin County, an entity or organization that Mr. Cogdell and I will agree upon, that this defendant will have to enroll in and take 15 hours of legal ethics as part of a continuing legal education course sponsored by the State Bar of Texas.
We're wrapping.
In addition,
all right, Carmen, as we wrap things up now, any final thoughts on how all of this came to be in a courtroom today for Texas's Attorney General?
No, as I said, it's really surprising, but I do think that we should be reminded that this resolution does save taxpayers money. It does put an end to the battle that has gone on for far longer than it ever should have. And it gives some closure to the victims in this case by giving them that restitution that they deserve.
All right, thank you very much, Carmen. We are going to keep chatting a little bit about this because it is quite the legal surprise.
Yes.
I think that's a fair way to categorize it. And we have a press conference now outside the courtroom. Let's go ahead and take a picture of that. Not quite sure, likely one of the attorneys speaking.
Would everyone have gotten the same? That's a good question. Actually,
all right, let's listen in.
I think history will teach us, or history will show us, that Ken Paxton would have never been prosecuted in this case but for his being the Attorney General. On the failure to register case, he's the only person in history that was prosecuted criminally after he was paid a $200 administrative fine through the State Securities Board. Let me repeat that. He's the only person in history to ever be prosecuted for failure to register after he paid a $200 administrative fee. I don't think any of this would have happened but for the fact that he was the Attorney General at the time they investigated it.
Mr. Cogdell, if he did nothing wrong, why is he paying back $300,000?
Good question. One of the answers to that is cheaper than what he'd had to pay me if we went to trial. The second answer is, look, there's no guarantee when you go in front of a trial. Any trial lawyer will tell you that. I can't possibly guarantee Ken Paxton or any other client what's going to happen if we go to trial. And in this case, I can guarantee him that the case will be dismissed if he does what he's going to do. So the answer to that's twofold. Number one, the economics were actually in his favor for not going to trial. And number two, it's a guaranteed dismissal at the end of the day.
I mean, why not go to trial to prove his innocence?
Because that's not the way this country was founded. You don't go to trial to prove your innocence. The Constitution says the exact opposite of that. And if I ever say that I'm going to prove the innocence of my client to a jury, I need the State Bar to call me up and ask me for my bar card back. That's not the way this works.
Do you have an update on the federal case
which
I do not.
is it still active?
I don't know. They don't call me. They don't text me. They don't send me Christmas cards. Nothing.
What are some of the other terms aside? Is there anything else besides the $300,000 that they'll have to?
That's pretty much all. There was the community service, which he's more than happy to do. There's 15 hours of ethics, which he's more than happy to do, and there's the payment of the restitution. That's pretty much it. So
what is the restitution?
it's Mr. Wice said it's slightly south of 300,000.
It's like 270,000.
270.
Mr. Cogdell, you and Mr. Hilder even have been picking juries here in Harris County for a long time. Is that a wild card? I mean, moving from Collin County to here, I mean, it could have gone the other way.
Well, it can always go the other way. You never know what 12 strangers are going to do with your future if you try a case anywhere, whether it's Collin County or Harris County. I'm not going to lie. The demographics were more favorable to Paxton and Collin County because it's red versus Harris County, which is blue. So any lawyer that says they wouldn't take that in consideration is either a fool or a liar. But I was confident we would win the case in either county. But confident is not a guarantee.
How does this diversion differ from prior conversations with the state?
Well, there was a prior pretrial diversion offered. I'll let Mr. Wice explain to you how it was different. Look, in my view, a pretrial diversion is a pretrial diversion is a pretrial diversion. For the record, I've never turned down a pretrial diversion in my life. I've only been doing this 42 years, so I'm a relative newcomer in the game, but I've never turned down pretrial diversion, and I'm damn sure not going to turn down pretrial diversion representing the Attorney General of the state of Texas. I may as well FedEx my bar card back to Austin if I did that.
In the last 9 years, have there ever been discussions of pretrial diversion before?
There were some historically, but look, to the prosecutor's credit, or the special prosecutor's credit, despite the length of this case being 9 years, and that's, as I said last time, that's longer than my first 3 marriages put together. That's a long time. But you never really focus, particularly as a prosecutor, on what's in front of you until it's in front of you. And this is the first time we really had an actual trial date, so they did what they should have done, interviewed the witnesses. I would argue that they should have interviewed them 9 years ago, but they came to, in my opinion, a rational and reasoned decision and decided to offer pretrial diversion.
There was no interviewing of the witnesses before this point?
And legal education requirements will look like? What will those entail?
Don't really know yet. It's kind of up to us, up to General Paxton to pick them, and then we'll coordinate with Mr. Wice and Mr. Silverman on exactly what they are.
Are there agencies or nonprofits that he plans to work at for his 100 hours?
Same answer. We don't know yet.
Going back to the charges before, these charges were out of Collin County, which is a red county, right? So obviously that jury panel felt like there was a crime committed here.
Well, that was a grand jury, and a grand jury is not the same as a trial jury.
You're right. Can you answer to that, though?
Yeah, a grand jury would indict a cheeseburger. The fact that he was indicted to me means nothing. I have little faith in the grand jury system. All in all, they hear one side of the evidence. The defendant is aware that the case is being presented. We don't get to cross-examine witnesses. We don't get to appear. We don't get to present our side. I mean, who couldn't win that argument? I don't give a damn that a grand jury indicted it. So what? Any other questions? One more question.
Has it been cleared in the Nate Paul case in the FBI investigation?
Again, I don't talk to the FBI. The FBI doesn't talk to me. I don't know what's going on in the federal investigation. I know in this case, we're glad to have this resolved. We're glad it worked out in our favor, and have a good day.
Within the last year, you've had 2 big wins.
Is that campaign funds or is that personal?
And you've been listening to Dan Cogdell, high-profile attorney representing Ken Paxton, and he has, as one would expect, as the defense attorney, sort of a different spin on all of this. He was saying that he believes the only reason that Ken Paxton was charged in this case was because he was a high-profile character, the Attorney General for the state of Texas. And Carmen Rowe joining us. Oh, wait a minute, we've got Brian Wice now up at the microphone. He is the remaining special prosecutor in this case after Ken Schaefer pulled out. Are we going to listen in to Brian Wice? Let's do that.
Collin County Criminal District Attorney Pro Tem. Judge's title is Special Prosecutor and all-around good guy. Before I answer your questions, I just kind of want to address a couple things in a restatement. 9 years ago, I was sworn in. as the Collin County Criminal District Attorney Pro Tem in this case, and the oath that I took is the oath that every prosecutor in Texas takes, which is that my primary duty is to seek justice and not to convict. I did everything and have done everything within my power to honor that oath to the people of the state of Texas in the face of some pretty personal attacks leveled against me by people in power in Collin County. At the end of the day, while I think the case could be made that justice was certainly delayed, I think the agreement that we've reached today underscores the fact that justice was not denied. To the victims in this case, to Mr. Paxton, and ultimately to the people of the state of Texas I've had the privilege of representing. The agreement that both sides reached today was not reached lightly. Since the agreement was prematurely revealed on Friday, both Mr. Silverman and I have been besieged by a torrent of phone calls, usually from blocked numbers, emails from accounts probably in Ukraine, from people who have expressed their monumental displeasure with the fact that these cases are being resolved with a pretrial intervention. I have been called everything but a child of God by these people, and to them I say, I appreciate your concern, and with all due respect, your truth is not the truth. You know 0.5% of what Mr. Silverman and I know about the facts of these cases. And the fact that all of these people have registered their monumental displeasure at what happened in these cases, I submit, probably should have been directed at the ballot box in, I don't know, 2016, 2020, and 2024. Much has been made of the fact that Mr. Paxton is the Attorney General and therefore should be held to a higher standard. A couple of quick takes. Number one, none of the conduct that we've alleged occurred on his watch as Attorney General. Number two, I know it's a cliche, but like most cliches, it's true. No one's above the law and no one's beneath it. And while I may personally disagree with Mr. Paxton's political ideology or some of the actions that he's taken as Attorney General, it would have been a violation of my oath as a prosecutor to take any of that into account. Why? Because, first of the pop culture references, this is business. This was never personal. And I am grateful that we had the opportunity, Jen and I, to express that to Mr. Paxton and his defense team a little while ago. Look, the criminal justice system, and I've been doing this for the better part of 4+ decades, makes two promises to any defendant, including Mr. Paxton, accused of any crime: a fair proceeding that produces a reliable result. And we believe this agreement does just that. And any defendant accused of any offense has the right to be treated with fairness, respect, and dignity. And I think that we have gone out of our way to show this defendant that. I think the question on everybody's mind, and I think we heard Mr. Cogdell asked, and it's ironic because we're coming up on Passover. If you've ever been to a Seder, one of the questions we ask is, why is tonight different from all other nights? Well, why is this PTI agreement different from the one that was offered 6 weeks ago? I think you heard all of the consequential differences in open court, but I'll just kind of restate them. Number one, as a prosecutor, from 35,000 feet, I have got to honor the oath that I took. And part of that oath primarily is ensuring public safety, that if the defendant who we are prosecuting is a predator, a threat, or a danger, it is incumbent upon us to lock that defendant up consistent with due process and fundamental fairness. That wasn't an issue in this case. And so what did our overarching concern for Mr. Silverman and I become? The victims. This case makes Byron Cook, former state representative and Mr. Paxton's mentor in the House, and his wife, and the late Joel Hochberg, who died at the age of 87 almost a year ago in Florida, it makes the Cooks and Mr. Hochberg's estate whole. And what's an outlier about this case, what made this deal radically different from the one that was offered 6 weeks ago, is that in a typical criminal case, victims are seldom, if ever, made whole. I mean, think about it. In a murder case, unfortunately, we don't get to resurrect the decedent. In a sex assault of a child case, we don't get to restore that youngster's sense of innocence. In a drug case, we don't get to pull that poison back off the street that a dope dealer's put out there. But in this case, we were able to do exactly that. In a moment, I'm going to read you a statement. In fact, I may do it right now, from Terry Jacobson, who represents the Hochbergs. The Cooks and the Hochbergs are grateful that they will receive restitution in full in connection with their Cervigy investments. This has been a long journey, and both the Cooks and Hochbergs appreciate the diligent legal work by Brian Wice and Judge Silverman to bring this very complicated legal matter to a conclusion. Again, that provision mattered more to me than anything else. In addition to that, the fact that this defendant, like every other defendant, is being required to complete 100 hours of community service. That matters. It's service to the community. And the fact that Mr. Paxton is going to have to perform that service, probably in conjunction with the food pantry or soup kitchen in Collin County. The 15 hours of continuing education and legal ethics matter to me. I'm a huge continuing legal education guy, and I believe that you can never get too many hours of ethics. And given the unique facts and circumstances of this case, Mr. Silverman and I believe that it was appropriate for Mr. Paxton, particularly as the Attorney General, to take 15 hours of ethics. That's 5 more times than we are required to take as lawyers. And that mattered to me. I think the other consideration is that, unlike your typical probationer, Mr. Paxton is not going to be supervised by a probation officer in this building who may have 150 probationers to look after. He's going to be supervised by the 2 guys that you're talking to right now. And Mr. Silverman and I, beginning 60 days from today, will have regular Zoom visits with Mr. Paxton and his counsel to make sure that he's doing what it is that he is supposed to do. And then, obviously, on another level, today's agreement brings finality to this process. And make no mistake, it's difficult for me to believe, as I was when I was running yesterday, that it's been 9 years almost to the day that I took the oath of office in this case. All right, so the question then becomes, how does this agreement differ from the one that was offered 6 weeks ago? Look, let me say this. Kent Schaefer is a great lawyer. I mean, he is at the top of his game, and his results speak for themselves. He and I have been friends for 45 years. We've had tremendous success together. But at the end of the day, in the words of Dave Mason, we just disagreed. The terms and conditions of the PTI that he proposed. And look, Kent had every right to move to withdraw for not being paid. I mean, think about it. Nobody expects anybody to work for free. And I don't blame him one iota. He had every right to pitch what he thought was a PTI that made sense to him. But again, we just disagreed because the agreement that was pitched 6 weeks ago, as everybody knows now, didn't have any of the consequential provisions that this one does. Restitution, first and foremost, that was a game changer. Secondly, community service like any other defendant. And this doubles the amount of community service that was proposed initially. And the 15 hours of legal ethics as opposed to the one random course in securities fraud that the initial PTI had to deal with.
Was that prior one an official offer?
Give me 1 sec, and then I'll answer your questions. The other question I think everybody has is this. Guys, what took 9 years? For those of you who were present at the speedy trial hearing 6 weeks ago, I think you know, but for your viewers and readers and the general public, you need to understand, like I said 6 weeks ago, this case, no pun intended, was a perfect storm of everything that could have derailed and delayed a prosecution. First of all, in August of 2017, Hurricane Harvey shut this courthouse. And then in March of 2020, COVID-19 shut the system down. We had a year's worth of pretrial litigation on the motions that Mr. Paxton had every right to file that the state successfully responded to. And then I got to say this. Judge Beall's predecessors in this case didn't do what we pay Harris County District judges, what, $150,000, $175,000 a year to do. Rule on motions timely. We're not asking that you do anything other than that. And her predecessors flat out refused to do that. We begged them. We begged them to rule on what the Court of Criminal Appeals ordered them to do in 2018, issue new payment orders to the special prosecutors. They didn't do that. And then when the time came for them to actually rule, they got it wrong. And that ruling, sending these cases back to Collin County, added another 3 years, as the Court of Criminal Appeals found last June. Her predecessor didn't even want to rule on Nicole DeBoard's unopposed motion to withdraw that was filed in June of 2018. Think about that. It's an unopposed motion. That's the 200 points on the SAT you get for spelling your name correctly. And he wouldn't even do that. And then obviously, our continuing attempts to be paid in this case, which is ongoing in the Court of Appeals right around the corner. And I'm confident now that these cases have concluded, that the Court of Appeals will ultimately decide that it's time to rule on that and to ensure that those of us who have labored over all these many years are adequately compensated. In the 4 weeks that Jed and I were involved in this case after the last setting, we were able to interview and re-interview almost a dozen witnesses who were either never interviewed or hadn't been interviewed since the Obama administration. And it was a result of that intensive interviewing and re-interviewing process that we had a sense of what these cases were, and more importantly, what they weren't. And I have nothing but disdain and contempt for defense attorneys who come to this building every day and plead their clients out without talking to a witness, looking at the law, or reading an offense report. And it would have been as equally shameful for us to have made a deal without understanding the true nature of the facts of these cases. All right, it's like Academy Award time. I want to thank some people. Look, obviously this gentleman to my left, Jed Silverman, has been... Awesome.
All right, so we are listening to Special Prosecutor Brian Wice, who has been on this case since 2015 when Paxton was first indicted. He said this pretrial intervention agreement was not reached lightly, and he made two very key points saying, look, none of the conduct alleged happened when Paxton was the AG, and also that no one is above the law. Now, we heard from Paxton's attorney Cogdell prior to Wice saying that there was a pretrial agreement that was offered 6 weeks ago, but Wice said what was important to him is that it included the consequential provisions. We're talking about the community service, we're talking about the continuing legal education, particularly on legal ethics for Paxton, and of course the restitution that he wanted in this. So both sides speaking today. Cogdell speaking just prior to Wice, saying that he is a prominent attorney here in the Houston area, saying that the Paxton was the only person in history to ever be prosecuted for failure to register after paying a registration fee. He says this wouldn't have happened if Ken Paxton wasn't the Texas Attorney General, and also saying that the reason they didn't want to go to trial is he doesn't want to go to trial to have to prove his client's innocence. So hearing from both the acting prosecutor and Paxton's defense in all of this, we're going to go back to KHOU 11 legal analyst Carmen Rowe. Carmen, you heard from both sides. What do you make about how this agreement was agreed upon?
Well, look, these are both tremendous trial attorneys. They've been on this case. They know more about it than I do. But what I heard was Brian Wice, the special prosecutor in this case, said that victims and their ability to receive restitution, as well as community service, were his priorities, as well as fairness to Kenneth Paxton in light of the allegations and the nonviolent nature of them. And then I heard Dan Cogdell tell us that, one, he doesn't think his client's done anything wrong. 2, that the criminalization of politics is very real. And 3, that a pretrial diversion intervention agreement like this one should always be accepted under circumstances where you take a risk going to trial. And I think he's right about all of those things. I think that Mr. Wice has spent an inordinate amount of time, energy, and effort, even under the umbrella of maybe not getting paid, and doing what he thinks is right, what he thinks is fair in this case, and with someone as prominent as Attorney General Kenneth Paxton.
A quick question before we wrap this, Carmen. I guess it was Mr. Wice that was really highlighting the differences between a first proffer about 6 weeks ago on an agreement and then the one that was finally agreed to. Was that first agreement, or first offer, if you will, do you know, did that contain a provision where Paxton would have had to admit guilt? Because he doesn't on this one.
Well, Mr. Wice didn't speak to that, so we don't know. And because it's part of pretrial negotiations, we may never know. But I would expect that given his law license, his position as the Attorney General, that that would have been a deal breaker for him. And I don't think it's surprising that today we are not getting any admission of guilt, and we are not getting any acknowledgement of responsibility from General Paxton.
All right, Carmen Rowe, KHOU 11 legal analyst, thank you very much for shedding light on a very complicated subject. But the bottom line is a pretrial intervention contract agreed to today by Ken Paxton, the Attorney General, and the special prosecutors over 3 felony charges over securities fraud. He will serve some community service, pay a little less than $300,000 in restitution, and take 15 hours of continuing legal classes on ethics, and not have to admit any guilt. And then the charges go away, nothing on his record.
Absolutely, if he fulfills the terms. Of course, the judge saying if he does not, there will be a speedy trial. We're going to have much more on this on KHOU.com. I'm Rekha Mutteraj with Sherman Chow. We'll see you back here at noon.
Had to take into consideration what the victim's feelings were about this case. And that's something as a criminal defense lawyer that maybe I lose sight of, but as a prosecutor, it's a huge part of the analysis in reaching a conclusion as to what the end result should be in a situation. And it is no small thing that the victims in this case are going to receive right around $300,000 in restitution from Ken Paxton. That is no small thing. And they are deeply, they didn't think that would happen. They did not, and frankly, 6 weeks ago when everything had come to surface about potentially pretrial intervention, that wasn't on the table. And that was a huge part of this resolution. This guy standing next to me has towed the line for the last 9 years on this case, has kept this case on life support when every single force out there that could kneecap this prosecution has attempted to do it. Unpaid, he kept going. Another thing that's important that everybody understands is that both of us are going to be monitoring the Attorney General for the next 18 months. And I can assure you, if he doesn't pay his restitution, doesn't comply with the terms of this pretrial intervention agreement, the judge said it a few minutes ago in this courtroom, we will be back in this courtroom. Over the last 6 weeks, I have gotten these cases ready for trial. That's not going to change. In the event he steps off the line, doesn't do what needs to be done, we're going to be standing in front of a jury and we're going to try this case. Ultimately, he's getting treated just like any other citizen in this county would be treated. We hope he's successful. We hope he pays the restitution and complies with the terms of this agreement. It's been an honor for me to work on this case. The sacrifice, it's nothing compared to the honor of representing the citizens of the state of Texas in doing this. I'm a competitor. I like to be in the courtroom. It's what I do. But you know what? That isn't the only thing that matters. I have to take into consideration the other forces, most importantly, the victims in the cases, which is a huge part, is why we're standing here today and have reached this resolution, which we hope is finality. Not a guarantee. We'll see. We'll see what happens over the next 18 months. But we do wish him good luck and hope that he's successful and hope that the restitution is paid in accordance with the agreement.
I want to say one thing, but before I take an additional question. It was reported at the last setting that apparently one of the reasons, or the reason why I have remained on these cases over the last 9 years is because, I want to see my name in the paper. That's just utter and sheer nonsense. I've had the privilege over the last 20 plus years
of being a legal analyst for Channel 2, KPRC TV. I'm on TV more than Law and Order reruns. I'm on TV more than any lawyer in this town. And the last thing that I need is a higher profile, particularly in light of the fact that my cell phone is now out there on the internet.
Mr. Wice, Mr. Cogdell had suggested that you came to the table for this deal because he didn't think you all could win in trial. What's your response to that?
You know what? Here's another sports analogy. Y'all are going to be shocked. Count them, because there's like a drinking game. Wice's sports analogies. Most of you are not old enough to remember a guy named Darrell Royal, who was the football coach at UT for like a generation. He used to say he hated the forward pass because 3 things could happen and 2 of them were bad. If we go to trial as prosecutors, 3 things can happen and 2 of them are bad. The jury hangs or he's acquitted. We are confident that a rational Harris County jury would have found our proof sufficient beyond a reasonable doubt. But you know what? That's why God built the courthouse, because you never know. And as Jed pointed out, if for some reason this defendant fails to do what he's promised to do, we're going to be back here and we're going to be ready to try the cases. Yes, sir.
On February 16th, you had said, without an acknowledgement of guilt, to me, that was worse than a slap on the wrist. You then said that wasn't going to happen on my watch. When did you change your mind, and what was it that changed your mind to get us to this point?
I think, as I've already said, that the intensive investigation and reinvestigation of the facts of these cases was the ultimate game changer. That, again, gave Jed and I a rational and factual understanding of what our chances for success were, not just on the 3rd-degree felony, but on the 2 first-degree felonies.
Why didn't that happen at some point earlier in the 9 years?
You know what? I'm not going to comment on that. I just think that the fact, look, I'm not in the Navy, but it happened on my watch. So regardless of, whatever division of responsibility existed at that time, I own that. And Jed owns that. And the fact that it was done matters more than the fact that it was done belatedly.
Can the public get a copy of this agreement?
No, absolutely not. It is not a public record. It is not subject to a PIA request, and it is not filed with the papers of the court.
What about the evidence? Do you intend to publicly disclose that?
There are 15 boxes of discovery. 21.
If we ask for it, can we get it?
You know what? I'm not going to speculate as to whether or not that would be subject to a PIA request. I know that Jed and I would do everything we could to keep that from happening.
Well, typically, isn't this a win for Ken Paxton? Yes, he has to do all these things, but he gets to keep his job. Law license isn't affected. He keeps his status, which is growing. How can anybody not see this as a win for him?
Okay, because
and avoids testifying.
And doesn't admit guilt.
Okay, all right. I can only answer one question at a time, so I'm going to answer your question first. Because the facts are stubborn things, and the facts are these. That ultimately this is a resolution that required him, whether inferentially or indirectly, to accept responsibility. In April of 2015, he accepted responsibility before the Texas State Securities Board, and I need to correct my good friend Mr. Cogdell. He didn't pay a $200 fine, he paid a $1,000 fine. And he acknowledged engaging in the underlying 3rd-degree felony. I am not going to expressly comment on whether or not he's accepted responsibility for the 1st-degree felonies. I think the public can make up its own mind, but the fact that he was willing to pay almost $300,000 in restitution, perform as much if not more community service than your typical defendant, and to take 5 times as many hours of legal ethics. Look, I'm not going to concern myself an iota as to who wins. Our oath that we took, and maybe you weren't listening, was our primary duty is to do justice and not to convict. So the question isn't whether or not who won, but was justice served. And I think the answer to that is unmistakably yes.
Mr. Wice, could you have gotten this deal under one of the previous 3 judges in another venue? Why not approach this deal 5 years ago, 8 years ago?
Lauren, because number one, these cases were in appellate orbit for almost as long as some of y'all had been alive. And once a case is on appeal, the trial court lacks, and here's a legal term, jurisdiction to be able to do anything on the case. These cases literally spent more time on appeal in the 5th Court of Appeals in Dallas, in the Court of Criminal Appeals in Austin, and the 1st Court of Appeals around the corner than they did in a trial court. And so at that point, without jurisdiction to act, a trial court, and for that matter, trial prosecutors, are unable to ultimately work to resolve a case.
So at no point in the last 9 years you had the chance to.
What's the
Go- I
timeline
could-
for that? The timeline for repaying the money to the victims? And does that have to come out of his personal account, or can you use campaign funds?
No, you cannot use campaign funds to pay personal debts. We are giving him the length of the PTI to be able to make restitution, but at the end of the day, as we explained to Mr. Paxton and the defense team, that the sooner he's able to comply with the terms and conditions of his PTI, we are not necessarily opposed to early terminating the PTI, that we would certainly consider it and keep it in mind.
So that's September
Brian,
2025,
in
right?
terms of
Yeah,
deterrent,
go ahead, Greg.
in terms of deterrent, what does this outcome say to folks who might be considering the same law-breaking behavior?
All right, let me break that down because that's a good question, Greg. I mean, let's talk about the third-degree felony. Ironically, up until Mr. Paxton was one of the House representatives who voted to make it a third-degree felony, it was an administrative proceeding. And Dan is right that the people we talked to at the State Securities Board, and we talked to everybody except the woman that cleans the green room there, told us that it was not common for anybody to be prosecuted and receive a criminal referral for the sole discrete act of violating Section 4, which is failing to register. It was only in conjunction with other offenses, such as securities fraud or any other aggravating factors, that someone was ultimately prosecuted. And of course, in this case, we had the Sergi investment and the securities fraud allegations. I think what it says is that there are consequences for not complying with the law. Look, make no mistake, Mr. Paxton has literally, and this is something that occurred to me the other day when I was running, in a way, he's been on pretrial diversion for the last 9 years, all right? He has had to do everything that, short of the restitution and community service and ethics, that this agreement requires him to do. And he's done so without an adjudication of guilt. So that, again, I would say, Greg, that this sends a message that you're not going to be treated any differently than any other defendant. Look, if any other defendant, again, assuming that there was no prior criminal history, no other aggravating factors, was able to make restitution, do community service, and I can't think of a single defendant that Jed and I have ever represented who had to do, wait, give me a second, oh yeah, legal ethics training or be supervised by the prosecutors. No. So I think that the message that it sends is that this defendant was treated fairly, with dignity and respect.
And frankly,
Brian, what do you say to the people who say Ken Paxton has just avoided testifying yet again? He didn't testify in his impeachment trial. Over all those 9 years, he hasn't testified.
Okay,
he hasn't testified in the whistleblower.
remind me who you are?
Molly.
Oh, Molly, right, the one whose editor took me out of the process. Molly, I'm not trying to be that guy, but in the words of noted legal sage Bryce Harper, that's kind of a clown question, bro. Because for those of us who didn't sleep through civics, we recognize that he had a Fifth Amendment right not to testify at his trial. So, again, with all due respect, you got to do better than that. Next question.
What do you hope Mr. Paxton learns in his legal ethics classes that you think he may need a refresher?
You know, that's a great question. I think what anybody, look, there's a reason why the state bar requires us to have 3 hours of legal ethics every year. And that's so we understand the fine line that distinguishes lawyers from grifters. And I think that the hours that he will take will reinstill in him the notion that lawyers are held to a standard of ethical conduct. That's why Jed and I have bar cards in our wallets. And that's why we're able to use our superhuman powers to represent citizens in this building who are accused of crime, sometimes unfairly, or as in this case, the people of the state of Texas.
Can you just confirm again the exact amount of the restitution?
Wow. I think it's like $271,000. And there are a series of checks. One to Byron Cook for his IRA, one to his wife, Kay, for her IRA, one to their foundation, and then another check to the estate of the late Joel Hochberg through his widow, and his son Mark is the executor of his estate.
And that's going to be paid?
Again, beginning as soon as tomorrow or as belatedly as next September.
Brian, what is your hope for the federal investigation that's going on right now?
You know, as I think Dan Cogdell put it succinctly, he doesn't talk to the feds and they don't talk to him. The sum total of my interchange with the Public Integrity Division of the U.S. Attorney's Office was an email that I sent asking them if their investigation was concluded so that we would be in a position to maybe make a particular offer that we were otherwise unable to make. And the prosecutor responded, "Thank you for your email. There's nothing I can share with you."
Brian, are there any outstanding issues with prosecutor pay, or does that?
Yeah, there is, and that matter is ongoing in two matters in the First Court of Appeals around the corner from this courthouse. Judge Beall, as you know, back in October, entered an order finding the Collin County local rule that I alluded to earlier that, again, pays me like, $3.15 an hour for the work that I did in 2015, unreasonable, arbitrary, and capricious. And so the Collin County auditor, who's got to process it for payment, and the Collin County commissioners who ultimately vote to put it on the agenda and pay it, have both filed challenges. And my position is simple, that Judge Beall's almost unlimited judicial discretion gives her the authority to find that provision unreasonable, arbitrary, and capricious over and out. And again, I'm hoping that the First Court of Appeals, and I intend to file an advisory with them in about another hour and a half, letting them know these cases are over, because one of Collin County's primary arguments is that we were not entitled to interim payment. And that ship's now left the port.
Thank you so much.
All right, thank you, everybody.
So Brian, how much are you owed?